Let's see Article 22, Protection against Arrest and Detention. Whenever a person commits a crime, the police arrests that person. He is taken to the courts, and if the court finds him guilty of the crime, then he is punished according to the law. Now, such arrest made after the conviction by the court is known as punitive detention. But in some cases, the police get a prior information of a crime that is about to happen. In such cases, the suspicious person is arrested to prevent him from committing a crime. This is known as preventive detention. Such arrests are made without a court trial. The intention of preventive detention is not to punish a person, but to prevent him from committing a crime. A preventive detention can be made only under a preventive detention law, whereas punitive detention can be made under ordinary laws. Article 22 grants protection against both these types of detentions. Let's see the protections provided in case of punitive detention. First, right to be informed of the grounds of arrest. So whenever a person is arrested under any ordinary law, he has the right to know why he is arrested, what is his crime. Second, right to consult and be defended by a legal practitioner. So after the arrest is done, the person has the right to get a lawyer and to defend his arrest. Third, an arrested person has to be produced before a magistrate within 24 hours. Now this excludes the journey time, because sometimes criminals are arrested from far off places like other states and even other countries. Fourth, right to be released after 24 hours unless the magistrate authorizes further detention. Now once he is produced before the court, if the court does not authorize further detention, then he has the right to be released. Now please note that these safeguards are not available to an enemy alien or a person arrested or detained under a preventive detention law. Further, according to the Supreme Court, these safeguards apply only to an act of a criminal or quasi-criminal nature. They do not cover arrest under the orders of a court, civil arrest, arrest on failure to pay the income tax, and deportation of an alien. Now let's see the protection in respect of preventive detention. First, the detention of a person cannot exceed 3 months. But this detention can be extended further by an advisory board consisting of High Court judges. Second, the grounds of detention should be communicated to the detained person. But facts that are considered to be against the public interest need not be disclosed. Third, the detained person should be afforded an opportunity to make a representation against the detention order. That is, they should be allowed to approach the court against such detention. This protection is available to both citizens as well as aliens. Now, Article 22 gives some additional powers to the Parliament. First, Parliament can prescribe the circumstances and the classes of cases in which a person can be detained for more than 3 months under a preventive detention law without obtaining the opinion of an advisory board. Second, the Parliament can also prescribe the maximum period for which a person can be detained in any classes of cases under a preventive detention law. And third, the Parliament can prescribe the procedure to be followed by an advisory board in an inquiry. Now let's see who has the power to make preventive detention laws. For reasons connected with defence, foreign affairs and the security of India, only Parliament can make a preventive detention law. But for reasons connected with the security of a state, the maintenance of public order and the maintenance of supplies and services essential to the community, both the Parliament as well as the state legislatures have concurrent powers to make a law of preventive detention. Now here's a list of preventive detention laws made by the Parliament so far. Preventive detention laws are not found in advanced democracies like the USA and Britain. It is considered as a colonial legacy in India, as such laws were present under the British rule. For example, the Bengal State Prisoners Regulation of 1818 and the Defence of India Act of 1939 provided for preventive detention. So should such laws continue to exist in modern India? Please write down your opinion in the comment section.